Hello friends, a very warm welcome to UnSarkari. And I am Vikas Bhardwaj continuing our understanding on different themes and sub-themes related to theory and practices of democracy. Today we are starting a very important and a pertinent topic, that is constitutionalism. We are going to understand why constitutionalism remains the core, and it is such an important theme that by understanding this theme you can basically later on remember and recall many parts and sub themes of the constitution easily if you understand the philosophy and if you understand the core concern, which is very much important to understand in a democracy like India. If we say constitutionalism, then one very important vocabulary or theme which must come to your mind is that of limited governments. So it is a limited governance or limited government, I would say, the two key words which are linked with constitutionalism. And according to some sources, this concept is linked to even little or no government also. But these are different viewpoints. There is no one concrete theory. There are different aspects. But more accurate, generic description would be that constitutional aims to stop arbitrary government. Okay, arbitrary government. That means whims and fancies of executive power. That means हम सत्ता में हैं. That means the idea that हमारी सरकार है. This kind of attitude, this kind of mindset, which goes against the tenets of equality, liberty, and even preamble and even the constitution. So think about emergency in India in 1975-77 when arbitrary suspension of rights highlighted why constitutionalism is essential to prevent unchecked power. That means we can say emergency was in contrast to ideas of constitutionalism. Constitutionalism is going to promote welfare ideas. Constitutionalism is going to promote access to justice and so forth. My question to you is, if constitutionalism is meant to stop arbitrariness, did India's emergency prove that even a written constitution can be vulnerable? Please write 100 to 150 words answer on this. Now let's understand this word we have been using again and again, arbitrariness. So at the most basic level, arbitrariness is the ability of rulers to rule intentionally. They want to do something intentionally with the vested interest or with the vested agenda, maybe to support certain community, maybe to support certain region, maybe to support certain political party, maybe to support certain ideology, with the total discretion. That means there is nothing to stop them to do so, and they advance their own interests over those of the ruled, yani over masses. So the precise definition of an arbitrary act and effective procedures for preventing it, it varies among constitutional traditions, because there is no one single tradition, there is no one single type of constitution. That is why it is an ongoing process. For example, colonial rule in India, they went on to implement laws like Rowlatt Act that was allowing detention without trial. So it was an example of arbitrariness that constitutionalism seeks to prevent. That is why our Indian freedom struggle is actually a very beautiful example, and it is a blueprint on which our constitution is based. That's why we say our forefathers, our ancestors, our freedom fighters, our martyrs, those patriotic, legendary gentlemen and women, girls and boys, male and female of all ages, they have sacrificed their lives so that we can stand today in a free India. Can we say that constitutional safeguards truly prevent rulers, or you can say those in power, from repeating colonial style arbitrary acts in modern democracies? Take a positive example like that of India, take another example like that of Pakistan. You can take example of China vis-a-vis India and so forth and write an answer. Now, what is political constitutionalism? Political constitutionalism is linked with the idea of dual system administration. The dual system administration, which is a very, very important part of representative democracy, the idea of mixed government is actually linked with the idea of dual system. Mixed government, dual system, these all ideas were present even in the ancient times in different forms. So monarchy, the king is there, and then you have the ministries. Aristocracy, you have the upper class, elite class ruling, and then other people are there. Democracy, so in democracy also there may be direct democracy, there may be, we have discussed how in Greek style there were democratic norms, and even in ancient India in Vedas, and also Sabha Samitis, and later on Mauryan period we have discussed. But each and every time there was certain kind of susceptibility, or you can say there was certain kind of vulnerability, which may lead to deteriorating situation into tyranny. That means you are now just not listening to anyone and anything, and you are just bulldozing everything under your own interests, like the way it happens in Pakistan or in other African countries. Oligarchy, that means only upper caste, upper class, the people from certain group, the people having certain control over resources, they are the only one. And finally, anarchy, whoever is able to do whatever they want to do, kind of a civil war situation. So by combining diverse sorts, moderation and proportion could be achieved, and that is what had been the long term stabilizing tradition of India. An amazing tradition, I would say. So, political constitutionalism is also linked with the aspect of arbitrary power, which was described as the ability of one person or one group to rule over another without considering their interests. Matsya Nyaya, or you can say there is a chaos, but finally there will be an order, and order cannot be there where there is arbitrariness. So hybrid governance, or the dual system that we said, it offers a picture of constitutionalism as being composed of institutions. Okay, there are number of institutions. So judiciary is one, legislature is one, and there are other institutions also, including, you can say, a free and fair elections, and then you have freedom to choose your occupation. There are different institutions. If I go with at the micro level, so those institutions are the structures that help the process of decision making, and the decision making becomes democratic in nature. So Indian Constitution's federal structure is a modern example of misgovernment, balancing union and state powers, and there is no domination by one authority or no dominance. In fact, our constitution may be tilted towards center, but there are enough federal safeguards. So again, on the same lines, I have a question for you. You have to write: India's federalism truly prevent arbitrary dominance, or does the union still hold disproportionate power? Disproportionate, that means you are questioning and you have to justify that it is disproportionate and more power should be there at the states. Because more power would have been there with the states, then states would have become more prosperous, more progressive, and much more they could have achieved than in the present times. Now, legal constitutionalism is another very important term. Article 16 of the French Declaration of Human and Citizen Rights in 1789. That's how when French Revolution took place. Now, what is the court? The court is a society where rights are not secured, or the separation of power established has no constitution at all. Now, again, I am repeating. This is the French Declaration of Human and Citizen Rights, a society where rights are not secured, or the separation of power established has no constitution at all. They say that will not be reflecting true democratic ideas, because separation of powers, dividing executive, legislative, and judicial function is a hallmark. It is the benchmark. It is so important. Lawmakers are compelled to avoid legislation that serve their own interest because they are subject to the same laws. Very important. Otherwise, all legislatures, including in Indian Parliament, they would have taken decisions just to benefit themselves. They are compelled to avoid legislation because they are also subject to the same laws, and the laws are independent, and that's how judiciary comes into picture, and that's how Indian constitution is uh, uh, is guarded and promoted and nurtured by judiciary in so many ways. So efficiency improvements arise when functions are separated. That is why in Indian constitution there is the concept of separation of powers. Keshwanand Bharti case 1973, in India upheld the basic structure doctrine, very important. It ensured that Parliament cannot amend the Constitution in ways that destroys separation of powers or that destroys fundamental rights. That means Keshwanand Bharati case went on to establish that there is something fundamental, something so basic in the Constitution which you cannot touch. Certain things are, you know, they cannot be tinkered with. Certain things are uncorruptible. Certain things are not supposed to be amended. They are the basic premises. And most beautiful aspect is that the list of the basic structure doctrine is increasing over a period of time and with the years. So please read that and you will understand how it is being interpreted. That is very important. So judicial review in India is a safeguard against arbitrariness, or does it risk creating judicial supremacy over elected representatives? What is your viewpoint? What is your answer on this? Do keep in mind the case study of the recent Indian vice president being asked, or you can say he left the post of vice president of India because of certain personal reasons. But what they are the real reasons? What kind of ideas do you think is there which must be spoken in public that can help in nurturing of democracy? So the two traditions that I discussed about, one is political constitutionalism, another is legal constitution. They are found side by side in numerous constitutions and they are present in most democracies like India. The first tradition is concerned with the structure, that is political constitutionalism, and the second, legal constitutionalism, is linked with the operation of democratic process, that is also visible and that is also applicable in India. So, two traditions. The second tradition, which we can say, it has largely superseded the first in the eyes of legal professionals because they are the one who are going to interpret the law, but they are not obviously running the show. A constitutional code should define and uphold jurisdictions and rights guaranteed by the Constitution. That is what the Indian Supreme Court and Indian examples reflect, because political constitutionalism is linked with parliamentary democracy and federalism. Legal constitutionalism is linked with Supreme Court's role as the guardian of fundamental rights or guardian of the Constitution. But I leave you with a question. Which tradition in India is stronger today? Political constitutionalism through democratic institutions? Like there are so many democratic institutions and the opposition parties keep on shouting that democracy is in danger, democratic institutions are in danger. So do right from that perspective, and legal constitutionalism through judicial activism. What do you think? Which tradition is more stronger, or do you think both are stronger, or do you think what should be the way forward? Do write in this direction, and I can assure you that your reading, writing, thinking, and also your ability to work smarter will definitely increase. Wishing you all success, and see you in the next lecture with UnSarkari.